So I just want to welcome you all to the American Constitutional Society's annual Supreme Court preview. This year we're, of course, discussing the 2010-2011 term that just started recently. And we are very lucky to have four of our great professors here to talk about some cases that I think are going to be very interesting as they involve all the fun stuff, murder, free speech, and video games.
Which are on a song.
Clearly. So, Professor Murchison, we have been lucky to have him here at WNL for over 20 years. He's served in multiple capacities, including acting dean, and he has also been the supervisor of our Black Lung Clinic. And he has written extensively on free speech. I'm doing abbreviated introductions because I want to leave as much time as possible for the people who actually came here to hear talk, not me. Professor Massie is one of our wonderful constitutional law professors. She's written a lot about constitutional issues. She's regularly interviewed about those as well as health law issues. Professor Fairfield is our resident all things electronic, e-commerce, video game expert. In a couple of years ago, he hosted a first-of-its-kind symposium about the legal and social challenges of virtual worlds that are built specifically for children. And Professor Bruck is our head of the Virginia Capital Case Clearinghouse, and he is an expert in criminal law. He has particular expertise in the area of capital cases and has been writing about those topics for over 20 years now. So without further ado, I will turn it over to Professor Murchison, and we will start talking about Snyder v. Phelps.
Thank you, ACS, for organizing this event and for inviting me. I've been asked to preview Snyder versus Phelps, which most of you know better than I because it's a chief source of this year's Davis moot court problem. I know Jessica Gusick would want me to say, please everybody show up on October 29th for the final rounds. I know Margaret Hannaful and Rachel Vargo have been working really hard on this whole venture this year, so please come that Friday. I guess it's a week from this Friday. Okay, Snyder v. Phelps, interesting case. Pitting tort law against the speech clause of the First Amendment. Not unlike the way that libel law clashed with the First Amendment in the 1964 case of New York Times versus Sullivan, or the way one of the privacy torts clashed with the First Amendment in Cox Broadcasting versus Cohn in 1975, or the intentional infliction of emotional distress tort clashed with the First Amendment in Hustler Magazine versus Falwell in 1988. All right, this case, like Hustler, features an intentional infliction of emotional distress claim. The case was brought not by a public figure, like Reverend Falwell, but by a private person, Albert Snyder, the father of a Marine killed in the line of duty in Iraq in 2006. Mr. Snyder brought the claim against a Kansas-based church known as the Westboro Baptist Church, founded by one Fred Phelps in 1955, possessed of about 60 to 70 members, 50 of whom are related by blood or marriage to Mr. Phelps. The church's own expert in the case described the church as practicing, quote, a fire and brimstone, unquote, fundamentalist religious faith. Now, among the church's beliefs is a belief that God despises homosexuality and is punishing the United States for its tolerance of homosexuality, particularly in the military. Church members have picketed military funeral services to assert that belief and have created a website in order to state that belief quite publicly. In this case, Mr. Snyder of York, Pennsylvania, made plans to bring his son's body to Maryland, to a Catholic church there, St. John's in Westminster, Maryland, to have a funeral service and burial. Fred Phelps learned of the planned service and funeral and decided to travel to the site in order to publicize the message of the Westboro Baptist Church. The church members notified police in advance that they would be coming. They brought signs with such statements as "God hates the USA," "America is doomed," "Fag troops." The funeral service was to be held at St. John's, as I said, a Catholic church in Westminster, Maryland. So some of the signs were about the Catholic Church. One sign said, "Pope in hell." Another sign said, "Priests rape boys." There were some other signs as well. One said, "Thank God for dead soldiers." One said, "God hates you." One said, "You're going to hell." And the contention of Mr. Snyder, the plaintiff, was that those last two signs, using the word "you," basically referred to Matthew Snyder, the Marine who had died in Iraq and who was about to be buried. "You're going to hell. God hates you." Now, there's some dispute about whether that was what the word "you" referred to. Undisputed in the case was that the church members complied with the local ordinances and complied with police directions with respect to being a certain distance from the church. They picketed the service for Matthew Snyder, but not the actual burial, which took place some miles away. They remained 1,000 feet from the church, where the memorial service was taking place. They stayed in a 25-foot by 10-foot area bounded by orange mesh snow fence material, designated by the police. Mr. Snyder, the plaintiff, did not actually see the signs until he saw a TV program later that evening with footage showing the signs. A week or so later, the church's website published what it called an epic, a narrative stating that Mr. Snyder had, quote, taught Matthew to defy his creator, that Mr. Snyder, quote, raised him for the devil, and so forth. Mr. Snyder heard that there was this website and did a Google search and saw it. All right, so Mr. Snyder brings 5 counts against Mr. Phelps and the Westboro Baptist Church. 5 Maryland state claims. One is libel. The second is invasion of privacy by public disclosure of private fact. A third claim is intentional infliction of emotional distress. A fourth is invasion of privacy by intrusion on seclusion or solitude of another person. And a fifth was a claim for civil conspiracy. Okay, the complaint was filed. Phelps moved for summary judgment. No, I'm not going to start talking about all that. My tort students. But yeah, there was a motion for summary judgment. And the motion for summary judgment by Phelps was that the statements on the signs and on the website were quote-unquote religious opinion. That they did not contain statements that were factual in nature, but were statements of religious opinion, and hence protected by the First Amendment from state tort law. The motion also cited Supreme Court cases stating that rhetorical hyperbole was a kind of speech that's protected by the First Amendment. All right, what happened with that motion? District Court, the trial judge, granted summary judgment on two of the claims. Libel, by saying, yeah, I don't see in these signs or on the website the predicate for a libel claim. Assertions of fact. The assertions seem to be assertions of religious opinion, said the trial judge. So the libel claim was thrown out. The other claim thrown out was the privacy claim for public disclosure of private fact. The trial judge said, I don't see any private information about the plaintiff contained on the website or on the signs. So what remained? The three other claims remain. IIED, intentional infliction of emotional distress, intrusion upon seclusion of another, and the claim for civil conspiracy. So those went to trial. I only have a few minutes. Intentional infliction of emotional distress is hard to prove. It was created that way by Prosser, among other people, to be a highly limited cause of action, where you have to show intent or recklessness in inflicting severe emotional distress. You have to show that that was that the intent was to use outrageous conduct, and that the victim actually suffered severe emotional distress, not mere insult or indignity, but severe emotional distress. Interestingly, there were no Maryland cases in which the IIED claim worked when it was simply a claim about speech. The question at trial was, gee, did that posting on the website, that epic narrative, constitute an intentional infliction of emotional distress? And did the protest 1,000 feet away from the funeral service constitute an intentional infliction of emotional distress? You can imagine that the Westboro Church made every effort at trial to remind the jury that it was a peaceful picketing that took place, that the speech involved matters of public politics, morality, and religion. And they reminded the testimony reminded the jury that the picketers left the scene 1,000 feet away as this funeral service actually began. They also reminded, through the testimony, reminded the jury that the evening telecast was not broadcast by the church. It was an independent news program that depicted the signs and recounted what had transpired that day. What about the intrusion claim? Intrusion on seclusion is defined as prying upon something which is and is entitled to be private in a manner highly offensive to a reasonable person. To be considered private, there has to be a reasonable expectation of privacy by the plaintiff. So it was really interesting that Mr. Snyder had to show that the place where the protest took place, that he, the plaintiff, had a reasonable expectation of privacy from picketers outside where the police had told them to be. Not right up at the church, and certainly nowhere near a burial ground. The view of the protest was obstructed by the Catholic school that was on the premises. So as I said, Mr. Snyder didn't see the protesters. And it was going to be interesting to see how the plaintiff would prove that the intrusion elements had been met by a posting on a website. Usually intrusion is about physical trespass, not a posting of speech on a website. Well, what happened? The jury came back with quite a sizable verdict for Mr. Snyder, the plaintiff. $2.9 million were awarded in compensatories and $8 million in punitives. As you all know, as you all can expect, the defendants made all kinds of post-trial motions to no avail. They did ask the trial judge to remit the damages, however, and the trial judge did so. He reduced the punitives to $2.1 million from $8 million, so that the total damages, when the dust settled on the trial, was $5 million. About half of what it originally had been when the jury came back. All right. What happened then? Went to the Fourth Circuit. Now, what's really interesting is that the Westboro Church, and where's Emerald? Do I have like 2 minutes left?
Yeah, sure.
Huh?
Yes.
Okay. The Westboro Church did not appeal, did not make a basis for the appeal, anything about whether the evidence was sufficient to meet the elements of those two torts. Instead, the appeal was a First Amendment appeal, that the verdict could not stand in light of the First Amendment. What did the Fourth Circuit do? 3-judge panel. Who were the judges? Judge Robert King, a Clinton appointee, appointed to the Fourth Circuit in 1998. He wrote the majority opinion. Also in the panel was Allison Duncan. She was appointed to the Fourth Circuit in 2003 by George W. Bush, confirmed by a vote of 93-0 in the Senate, interestingly enough. The third judge was Dennis Shedd. He was also a George W. Bush appointee, appointed in 2002. Much closer vote on him in the Senate. Shedd wrote a concurrence. He said, let's overturn the whole verdict, but not on First Amendment grounds. Let's overturn the whole thing because the elements weren't proved satisfactorily. The evidence simply wasn't sufficient. And so therefore, the verdict cannot stand. That was the concurring judge. He said, let's throw the whole thing out on insufficient evidence. The other 2 judges, however, Judges King and Duncan, they threw out the verdict, the $5 million verdict for the plaintiff, on First Amendment grounds. And Emerald, I've got 1 minute left. So what grounds? I know the grounds were that the Fourth Circuit relied heavily on the cases that come from the area mainly of libel law, stating that to be actionable, a statement must be an assertion of fact, whether true or false, but that statements of opinion that are not factual in nature, either true or false, that are not provably true or false, that are not verifiable, count as opinion or as rhetorical hyperbole, and that those simply are not actionable under the First Amendment. So it was a pretty traditional First Amendment. It was a wonderful review. I told my students from mass media law, review the case by reading the Fourth Circuit opinion because all the cases we read are in there. One last thing I'll say. The Fourth Circuit cited a really interesting other Fourth Circuit opinion that came out about a year or 2 ago. In that case, one of the defense contractors in Iraq, CACI Incorporated, was suing a left-wing talk show host. There is such a thing. The defense contractor was suing Randy Rhodes, who for Air America used to have a left-leaning radio talk show. And she had said on the air, right after those terrible photographs from Abu Ghraib came out, she had said, well, here's a quote. She had said that CACI and other private defense contractors for the U.S. in Iraq had employed mercenaries all over the country of Iraq, killing people. And she said that CACI and other contractors were hired killers. Well, CACI sued her for libel, saying, hey, you're accusing us of murder. That's defamatory. The Fourth Circuit held that there could be no successful claim against Randy Rhoads, the talk show host, for saying that it was rhetorical hyperbole, that no reasonable receiver of that speech could interpret it except as rhetorical hyperbole, not as some factual assertion that these people had actually killed anybody, but as rhetorical hyperbole meant to stir up debate and comment in the U.S. about the situation in Iraq. So the Fourth Circuit relied on that case to find, in this case, that the church was protected by the First Amendment. Sorry for talking so long. Last thing I'll say is that the Supreme Court had oral argument on this recently, and my prediction is that it's going to be a really close case in which maybe the court will try to find a way to let the plaintiffs have something. There was a lot of sympathy expressed for Mr. Snyder by a range of justices. I don't think that would be the right outcome, but I think that may be what they do.
I told everyone this always runs over an hour, so good evening. Thanks to the ACS for arranging this evening and for inviting me here. The case I'm going to talk about is called Flores-Villar versus United States. It comes from the Ninth Circuit Court of Appeals, 2008 decision. And it's a gender discrimination case. The question presented here, as it's stated on the cert petition, is whether the United States Supreme Court's decision in a case called Wynn versus INS, Immigration and Naturalization Service, decided in 2001, permits gender discrimination that is not biologically based. Now, the way this question comes about. At the time that Ruben Flores-Villar was born on October 7, 1974 in Tijuana, Mexico, the Federal Immigration and Nationality Act provided that when a person was born out of wedlock and outside the territory or possessions of the United States, then whether or not a U.S. citizen parent could transmit citizenship to that baby varied depending on whether we were talking about the mother, the female parent, or the father, the male parent. For the U.S. citizen, if the U.S. citizen parent was the mother, then the only requirement in the statute was, quote, she could transmit the citizenship to her child, quote, if she had previously been physically present in the United States or one of its outlying possessions for a continuous period of 1 year. But if the U.S. citizen parent of the out-of-wedlock child was the father, then in order to transmit citizenship to the child, he must have resided in the United States, quote, for a period or periods totaling not less than 10 years, at least 5 of which were after attaining the age of 14 years. Furthermore, he has to have taken steps to legitimate the child during the child's minority, or to sign a sworn statement that he was, in fact, the father of the child, or there must have been a court of competent jurisdiction finding paternity. Now, in this particular case, Ruben Flores-Villar, born in Tijuana on October 7, 1974, to a non-citizen mother and a U.S. citizen father, who was only 16 years old. Now, the obvious problem is that as a 16-year-old, there was no way that he could satisfy the residency requirement of residing in the United States or one of its territories for at least 5 years after reaching the age of 14, since he was only 2 years older than 14. So, a father would have to be a minimum age of 19 to pass that test. Now, Flores Villar's mother apparently didn't really want to have anything to do with him. So, the father and his mother, the paternal grandmother, brought the child when he was 2 months old to the United States for medical treatment. He was raised by them, his father and his paternal grandmother, in San Diego. So that's where he grew up. When he was 11 years old, his father filed an acknowledgement of paternity with the civil registry in Mexico. So he met the requirement of legitimation or of acknowledgement of paternity. Other possibility being a court order finding paternity. So that, of course, is a biologically based kind of requirement. We know, we think, the court takes it for granted that when the baby's born, we know who the mother is. They have never heard of gestational surrogacy. But anyway, it's assumed that we know who the mother is, but the father, we don't necessarily know. So this requirement that the father somehow acknowledge or legitimate the child, or that there be an outstanding court order, is a common one in this country as well. It must happen during the minority of the child. I mean, it's a common one in states that regulate these things. But unfortunately, although his father had acknowledged paternity, etc., he was, of course, only 16 when the child was born. And in 1997, when Flores Villar was 22 years old, he was convicted of importing marijuana into this country in violation of federal drug laws. Really stupid thing to do. He was deported as a non-citizen and was in fact removed from the U.S. during the next several years on 6 different occasions. He was finally arrested and charged with being a deported alien found in the United States after deportation in violation of federal laws. His defense was that he believed he was a U.S. citizen through his father. Among other things, the court didn't think that really explained why he crossed over the border into California at some quite distant remove from any sort of official guard place or official border crossing, but he did walk across into California out there in the middle of the desert from Mexico, some distance away from anything else. In any event, his defense that he truly believed he was a U.S. citizen didn't wash very well. He did apply for a certificate of citizenship at that time, but that was denied on the grounds that his father had not resided in the U.S. for 5 years after the age of 14. So he decided on a bench trial rather than a jury trial. He was convicted. Okay, the Ninth Circuit Court of Appeals affirmed that conviction. They held that their result was governed by the 2001 Supreme Court case of Wen versus INS, Immigration and Naturalization Service. There, the Supreme Court had upheld the gender distinctions in the Federal Immigration and Nationality Act. But the difference was that in Wen versus INS, the requirement that wasn't met was the requirement of legitimation or acknowledgement or obtaining of a court order during the child's minority. The father had in fact brought up the child. He tried to go get this order when the child was in his 20s and got into trouble, but it was too late for that. That, of course, is a biologically based requirement. And as I mentioned, similar state laws have been upheld. Particularly, those cases tend to arise in inheritance kinds of issues and questions. Whether a child is entitled to inherit from a male that he claims to be his father. and they usually require that certain legal steps have been taken, usually during the minority of the child, but certainly before the death of the father, and they've always been upheld. Now, the validity of gender discrimination is evaluated under the Equal Protection Clause of the 14th Amendment, if you're talking about states and their governments and policies, or under the Due Process Clause of the 5th Amendment, if you're talking about the federal government. Here, it's the federal government. The 5th Amendment Due Process Clause is deemed to have what's called an equal protection component, which basically provides the same things as the Equal Protection Clause does to the states. Under equal protection jurisprudence, gender is called a quasi-suspect classification. That means that in order to uphold a classification based on gender, or gender lines, there must be an important governmental interest at stake, and the means used by the government for achieving that important interest must be substantially related to achieving that interest. In Wen versus INS, the Supreme Court identified two important state interests for the gender classification there. First, assuring that a biological relationship exists. That has been met in this case by the fact that Flores Villar's father went to Mexico and signed with the civil registry, signed his paternity. Second, ensuring that the child and citizen parent, and here's the wording of this interest, quote, have some demonstrated opportunity to develop a relationship that consists of real everyday ties, providing a connection between child and citizen parent, and in turn the United States. Now the emphasis here is on the word opportunity. And the way the court looks at it, that opportunity inheres in the birth process. That is, at the time of birth, only the mother may be present, and she, at that time, has the opportunity to form these ties with the child, and then in turn the child, if she's a U.S. citizen, she can transmit her citizenship by these ties. She has the opportunity for these ties, and then in turn there's the opportunity for the child to form the ties with the U.S. The father's not deemed to have that same opportunity because his identity may not even be known. He may not be there, probably is not there. We may or may not ever find him. Now, in this case, of course, we know that the father was a very active presence in the child's life. The child grew up in San Diego, and certainly there was opportunity for these ties to develop and ties to the U.S. as well, but it's that opportunity at birth that seems to count in the court's eyes. The third identifiable interest that was not actually dealt with in Wen versus United States, but is talked about in this case and was talked about by the Ninth Circuit, is the prevention of statelessness for a child born out of wedlock. Now, a number of countries don't have the same rule we have that a child born in the country will be deemed a citizen of that country. Many countries use bloodlines to establish citizenship. And if the only person around is the mother, then it's deemed that she's got to be the source of the bloodlines establishing citizenship. Now, actually, Iran doesn't follow that rule, but the Ninth Circuit didn't care much what Iranian law was. So they say it's the father, and we don't know who he is or where he is. But in any event, prevention of statelessness was found by the Ninth Circuit Court of Appeals to justify the lenience for the mother in having to have resided in the United States for only a period of 1 year, whereas a longer period of residence could be required for the father. Now, Flores Villar is trying to argue, he's got to attack this statute on that gender distinction, right? I mean, that gender distinction that says it matters how long the parent has lived in the U.S., has resided in the U.S. 1 year. Interestingly, since Flores Villar was born, this law has been amended in 1986. And now, with respect to the father, it says he needs to have lived in the U.S. for a period or periods, to actually reside in the U.S. for a period or periods totaling 5 years, not 10, 2 of which must be after attaining the age of 14, not 5 of which. Sounds tailor-made for this case. But of course, it's a day late and a dollar short as far as Villar is concerned. Can't help him out. It wasn't the law at the time of his birth. But it certainly sounds like, a possible argument that, well, this 10-year requirement and the 5-year post-age 14 requirement is not really substantially related to achieving any of these important governmental interests, because if it were, Congress couldn't have changed it quite so glibly. Now, he needs to be able to invalidate this particular gender differentiation, because if he is successful, then he will be deemed to have been a citizen from birth on. That is crucial in this case, because if he was a citizen from birth on, then he's fine. All those deportations were, in fact, illegal. However, the government is also arguing that the United States, the federal government, has the authority under Article 1, Section 8, Clause 4, to regulate immigration and naturalization, which is certainly the case. If that law is deemed to apply to this child, then he can never enter the United States again, because a deported alien found in this country and convicted on that criminal charge not only will be deported, but will never be allowed to visit. It doesn't matter whether he gets married to a U.S. citizen. It doesn't matter if he has U.S. citizen children. He could apply for a waiver. I've heard from a knowledgeable immigration and naturalization lawyer that really those waivers are never granted. So the result for him, if he loses, is dire. He can never come into this country again. But if he is deemed to be, if this gender distinction is struck down, and he's deemed to be a U.S. citizen from his birth onward, then immigration and naturalization law would never touch him, because he would have been a U.S. citizen, just like probably most of us anyway, in this room, and you wouldn't have to worry about Article 1, Section 8, Clause 4. It's going to be very interesting, I think, to see how the court sorts this out. And whether they say, it's been phrased, can that prior case, which related to a distinction that was biologically based, does it really govern this case, where a residency requirement, a durational residency requirement, seems not to be related to the biology inherent in the whole parent-child situation. I don't know if I want to try to predict how this one's going to come out. But it's interesting to me that they even took the case, considering that the law has now changed. And there won't be very many people to whom this could even possibly apply. So, we'll see what happens.
Well, thanks for coming this evening, and thanks for inviting me. I'm going to talk about Schwarzenegger versus EMA, which is the violent video games case. And I have to say that since I started looking at this case, I've become aware that my young daughters are being constantly exposed to gruesome and violent media content on a daily basis. In one scene, an entire family is executed. Men, women, and children are slaughtered. In another scene, a guy who's fleeing a battle runs into a tent to try to get away from the fight, and the woman who takes him in waits till he falls asleep and drives a tent peg through his skull into the ground. In the third, arguably climactic scene, the protagonist is arrested, brutalized, whipped, flogged through the streets, and crucified. Violence, violence has a history in our culture. When the state of California therefore says that we can apply the law of obscenity such that the state of California can ban access to minors to what they deem violent video games, I have to ask, where does that argument stop? So to give you the various sides in this fight, the obscenity standard as set forth in Ginsburg essentially says that a state legislature or a city just merely has to have a rational basis to keep porn out of the hands of kids. And we can understand why, right? Sex also has a history in our culture. And the Supreme Court said in Ginsburg that even porn that we consider non-obscene, that is soft-core porn, which we wouldn't be able to keep out of the hands of adults under an obscenity standard, we can still keep that away from kids. And that makes all kinds of sense. And I'm seeing some heads nodding, right? When the state of California says it wants to do the same thing for violence, that is, it wants to be able to say we have any articulable rational basis, and that means we can keep violence out of the hands of children, I get very nervous. Now, the very reason that I'm talking to you today is probably not because I'm known far and wide as a First Amendment scholar. It's likely because I'm a video game junkie. So I'll admit some bias. But also, I think that's indicative of what's gone horribly wrong in this case, right? The very fact that we think video games are different is demonstrably incorrect. I mean, I find it striking that the respondents, that is the Entertainment Merchants Association, have to spend more or less a third of their brief before the Supreme Court explaining that video games constitute expressive free speech. This is clearly a court that's never played BioShock. Right? I mean, why would you have to make this argument to anyone who's seen the brilliant send-up of Ayn Rand's objectivist philosophy, and of course the BioShock 2, if you want to take on the progressivists, right? They're equal opportunity parodists here. The idea that this incredibly expressive medium should, because of its extra expressiveness, that is the extra interactivity it provides, be denied First Amendment protection is simply laughable. All right, but we are struggling against that presumption, right? The presumption that somehow video games are for kids. Video games don't have expressive meaning, but yet we're going to have the extra ability to regulate them because of their interactivity. So clearly, I follow where the district court and the Court of Appeals came down in this case, and in fact, every other court in the country that has looked at this issue, they have all said where the government wants to regulate speech because of its content, right? Not the time, place, and manner in which the content is expressed, but because of its content, that is because the video game is violent. Right? They want to, and we presume because the state legislature wouldn't dare, and the district court even suggested that there is violence and then there's violence, right? That there's violence that can't be obscene. For example, the Allied invasion, right, of Normandy is considered violence that can't possibly be obscene, no matter how much blood and guts there is, because our soldiers aren't committing obscenity, we presume, when they defend the country, and yet Go on Postal 2, which was the sort of poster child for a bad video game, the violence there was obscene, of course the only difference being the content of the message that the violence is conveying. So where a legislature seeks to control the content of a message, normally we apply the exact opposite, the highest level of scrutiny rather than the lowest. Strict scrutiny, I'm sure most of you are familiar with it by now, and we're talking about intermediate scrutiny, right? So instead of having a protected category and having to substantially advance that interest in strict scrutiny, you have to have a compelling state interest, and the regulation must be narrowly tailored. In fact, sometimes the court expresses it as so narrowly tailored that there can be no less restrictive alternative. Now, this does lead to some interesting analysis. First of all, we're all very worried that the Supreme Court took this case to endorse the obscenity standard for violence. Because, as I started with my biblical analogy, there's no place that argument stops, right? Video games are like every other form of content. We've seen this argument for a lot of other new media forms, right? That they're somehow mystical and different. So we saw it for plays in the Victorian era. We saw it for comic books in the 50s. We've heard it for movies, right? We certainly saw it for television, broadly leveled charges of corrupting the youth. Now we're just seeing it for video games. So there's no articulable reason why this should stop with video games. There's no legitimate reason why that would be the case. And if the court does adopt this obscenity standard, they're not only putting pretty much the last successful American industry in serious jeopardy, but they're also laying down a rule that has a lot broader impact. Let me give you a bit of an idea of why, right? Because some of you might be thinking, gee, what do I care? I mean, I go to the movie theater and I see R-rated movies all the time, and kids aren't allowed into those. So why in the world would I care if the state of California says you can't sell a violent video game to a minor, and you have to have a label on the box saying 18 or higher? Well, here's why. The court's been very nervous in the past about these kinds of requirements where the vendor has no earthly way of knowing who they're talking to. So in the when they struck down, for example, a lot of the obscenity restrictions in the Communications Decency Act, the court said, essentially, we're not going to dumb down the conversations of adults to the level of children. And the problem is that a vendor over the internet can have no idea who they're talking to. And if you look at the statute really does presume that you're going to GameStop to buy your video games. Yeah, that business model, I mean, Blockbuster just went under, GameStop's next, right? People are buying video games direct download. This is how digital content gets distributed, and we're rapidly phasing out the idea that you would sort of get in a car, drive down to the store to get digital content. So in the same way, it would allow the state of California to regulate the entire United States, possibly the entire world, and furthermore, you've got merchants who are really stuck. What do? Deny all downloads to IP addresses that appear to be in the state of California? That won't defend them because you can use a proxy. You can get around that. You can appear to be coming out of usually servers somewhere in the former Soviet Union, right? And you're presumably allowed to sell video games to those people, violent video games, even if not to children in California. The problem is that the child in California is using a simple proxy, as does everyone. And so there's no way of knowing. Tor Onion Router, folks. Use it. Love it. All right. So the second thing is, the second problem, and this is very similar, is that the content in video games today is being described by the statute in an antiquated fashion. So the statute clearly has this view of video game manufacturing that's more or less like Hollywood. Right? You can see why. The video game industry has a bigger budget than Hollywood. They now do these big budget productions where they've got a lot of flashy graphics, and they do generate a lot of content. So you can see why the California legislature thought, I know what we'll do. We'll make the manufacturers and the vendors liable for the content of the video game. Yeah, again, not so much how we're making video games these days. If you think about a game like Little Big Planet, came out a while back. It's sort of a simple platformer. The trick being, of course, that the players, the users design the content for it. Now, in the industry, this is called user-generated content. And the most successful games are ones that provide a framework for users to generate their own material. Now, how in the world can you have a vendor be liable for the content of a video game when the vendor is merely creating a platform, a set of tools? The content of the game is generally created, or is often created, by the public. So these are two very practical, I'll say, industry reasons that are under-discussed in the brief, but might briefing the parties, but might be reasons why we would take quite seriously the claim that we're hearing from the EMA that this statute deeply undermines the industry. As for predictive judgments, I have to say I'm very worried about this. For two reasons. One, because every court so far has gotten this right. There is no circuit split. Right? The courts are very clear on this. Why in the world would the Supreme Court take this where there's an emerging consensus and everyone's gotten this right so far? The second reason is that we might think that the new appointees to the Supreme Court will not be of any progressive help. That is, Justice Kagan in particular has done, among her few academic publications, is one that's very pro-government on this issue, essentially saying the government can, if sufficiently pure in heart, regulate all kinds of speech, and that makes people like me deeply nervous. On the other hand, the court has been quite good over the past 15 years on First Amendment cases, and Justice Kagan and others have asked a lot of hard questions of the parties in these First Amendment cases. So it is anybody's guess. I have a sinking suspicion that the court may be, I hope that they would reverse, but come out somewhere short of saying rational basis review for obscenity, because coming back to the beginning, there's a lot of violence in our culture that we probably think should not be regulated by the government. And I'll leave that there.
Well, last but not least, I'm going to talk to you very briefly about not one but two death penalty related cases that have already been argued this term, one on October 6th and the other on October 13th. I'll tell you a little bit about the facts because they sort of sound like no-brainers. John Thompson was a man in New Orleans who was charged with a murder, and before that charged with a carjacking to sort of soften him up for the murder case. He was convicted of the carjacking, which made it impossible for him to testify in his own defense of the murder case because the jury would find out that he had a carjacking conviction. So he did not testify, was convicted of murder and sentenced to death. It emerged many years later. He came within a couple of days of being executed. And finally, after he had been on death row, or at least about 14 years after his arrest, he was in prison for a total of 18 years, it emerged that an assistant district attorney in New Orleans had hidden the fact that a blood test, blood from the carjacker at the first of these two crimes, had a blood type different than John Thompson's. This all occurred prior to the era of DNA, but nevertheless, it's a different blood type. They have the wrong guy. Thompson had developed, his lawyers had developed an alternate suspect who happened to be the guy who testified against him, critical state's witness in both cases. Blood type matched him, as did the physical description from the murder, which was also hidden from the defense. All of this eventually came out, and Thompson, the armed robbery, the carjacking case was set aside. He was given a new trial on the murder. The jury, given all of the evidence that had been hidden by the DA's office for all of these years, deliberated 35 minutes and acquitted him. He was released. He now runs an organization in New Orleans called Resurrection After Exoneration, which works with exonerated, wrongfully convicted former prison inmates, trying to help them with reentry and to rebuild their lives after this sort of traumatic experience. Well, it seems fairly self-evident that he had a pretty good civil lawsuit. The lawyers that had helped save his life thought so, and brought an action against the DA's office under 28 U.S. Code 1983, the civil rights statute, for violation of very fundamental federal civil rights. The jury gave him $1 million for every year that he had spent on death row, a $14 million verdict. That was affirmed by an equally divided vote of 8-8 by the in-bank Fifth Circuit, and the Supreme Court granted the DA's petition for cert to review that $14 million verdict. I think that would be a fairly easy issue. Well, the second case seems even easier. It's a DNA case involving a man in Texas named Henry Skinner, whose execution was stayed by the Supreme Court 45 minutes before he was to have been executed this past March. Why? Because the state of Texas had a large quantity of untested blood from the crime scene, which Skinner had been arguing for quite some time, would show, or might show, he claimed that it would show, that the murderer was not actually him, but, again, an alternate suspect, the uncle of the murder victims, or one of the three murder victims, who he fairly plausibly had a theory that this man had both the inclination and the motive to have committed this crime. Skinner claimed that he was passed out drunk at the scene of the crime and truly didn't know who had committed it except that it wasn't him. Well, there's untested DNA, untested hair evidence. Again, Skinner sued in federal court under the same statute, asking for an order from the federal court requiring the state of Texas to test this DNA evidence, which the DA's office had for many years refused to do. No-brainer. We've got the evidence. The man's about to be executed. He claims it would show that he was innocent. Why wouldn't they test it? And if they wouldn't, surely he had a constitutional right to force them to do it. Well, as it turns out, both these cases are not actually about the issues that I've just described. They represent a kind of case which is more and more common in the Supreme Court and in our system, at least in the federal courts, which have to do with the closing of the courthouse doors, with legal doctrines that make it more and more and more difficult for litigants claiming constitutional violations, at least, to have the merits of their cases heard at all. So what is the issue in the first case, the $14 million verdict by the man that spent 18 years wrongfully incarcerated and was newly executed for a crime that he clearly did not commit? His immediate difficulty is that the prosecutors in a fairly well-established line of Supreme Court cases have absolute immunity for being sued for acts that they conduct in their official duties in the trial of cases. And that absolute immunity has been thought to be necessary so that prosecutors can prosecute without feeling that they have to constantly look over their shoulder and worry about being sued if things don't go right. Which means that the assistant district attorney who hid this blood evidence can't be sued. And he couldn't be sued anyway because he died during his long since died, nor can the three other assistant district attorneys about whom he revealed this evidence at the time of the trial be sued because they also have absolute immunity. So Thompson brought the lawsuit against the district attorney's office as such. But in order to do that, there's another line of cases that say that respondeat superior, the idea that the boss is responsible for the acts of his subordinates, does not apply in civil rights litigation at all, whether they involve prosecutors or anybody else. The office can't be automatically held responsible for what the employees do. Rather, you have to show that the office has a policy of some sort that caused the constitutional violation. So Thompson's legal theory was that what caused the violation was the New Orleans district attorney's failure over many, many years to train their assistant district attorneys, the line prosecutors, in the obligations that the Constitution imposes under the line of cases Brady versus Maryland, the constitutional duty to turn over exculpatory or mitigating evidence, evidence that is helpful, strongly helpful to defendants, and something that you learn about in first year criminal procedure, I guess it's now second year criminal procedure here, and that turned out to be exactly the line of defense that the DA's office in New Orleans has taken, which is we don't have to train our lawyers because they have been to law school. And when you go to law school, you find out all about the vagaries and ins and outs and technicalities of the doctrine of Brady versus Maryland. And as a newly minted lawyer, everybody already knows that they have to turn over favorable evidence. They have to know, presumably, how favorable it has to be, under what circumstances and what issues it has to go to, and when things have to be turned over to the defense and when they don't. So that question, was there a duty that was breached by the New Orleans District Attorney's Office in a duty to train or otherwise inform their employees, their assistant prosecutors, of their duty to turn over favorable evidence, is what this verdict will turn on. The Supreme Court has said that generally, in order to establish a failure to train claim against a municipality, government agency, you have to show that there has been a pattern of violations which put the agency on notice that it had to train its employees. They haven't been able to establish that here, although there's a great deal of evidence that the Orleans Parish District Attorney's Office had sort of a culture of playing it absolutely close to the best as they possibly could, turning over as little evidence to the defense as they could in every case, and that their published materials for their prosecutors didn't even get the basic constitutional doctrine right. It was full of mistakes. But in any event, They weren't able to show a pattern of violations before the date of this trial. And so they had to say that the duty to train was inherent in the situation, that it was self-evident that any district attorney should have known that this is something you have to do. The only example the Supreme Court has ever come up with of that sort of situation is the duty to train police officers in the use of deadly force. You can't give a police officer a gun and tell him or her to enforce the law without providing training on what the Constitution requires as far as when you can and can't use deadly force. And in effect, Mr. Thompson is arguing that this is analogous, particularly because prosecutors make these decisions with no judicial oversight. They make the decision in your office. Nobody knows except the prosecutor him or herself whether there's evidence that's not being disclosed. DA's response is this prosecutor was a rogue prosecutor who did something that everybody knew was illegal. All the training in the world wouldn't have made any difference. Couldn't have stopped this, and therefore whatever we did and didn't do in our office did not cause this violation. And the Supreme Court will have to decide whether or not Mr. Thompson has slipped through this tiny eye of the needle in order to avoid the doctrines of prosecutorial immunity and the lack of a respondeat superior in civil rights cases, and establish this narrow exception that would allow him to collect against the this judgment against the DA's office in New Orleans. My prediction on this is that he will probably fail by a vote of 5-4. Justice Kennedy, as so often a swing vote, seemed extremely skeptical of the claim and asked the lawyer, a number of the justices asked the lawyer, well, what exactly does this training have to consist of, according to you? And Chief Justice Roberts at one point made a very sarcastic comment about, well, I'm not really an expert on criminal law either. I suppose I need to be trained. So you can see where this was going. In the meantime, Mr. Thompson is waiting to see whether or not he will receive recompense for this rather extraordinary wrong that was done to him, or whether there simply is no remedy available under federal law. The second case, the untested DNA. The issue there, again, is an enormous tangle of procedural thicket, which, if I had another hour, I don't think I could do justice in explaining it, but I'll try to do it in about 2 or 3 minutes. Here's the problem. Generally, prisoners challenge have the ability to challenge their convictions and death sentences in federal court if they claim that they're in violation of the federal Constitution. That's called habeas corpus. However, there have been such a raft of restrictions, first created by the Supreme Court and then in 1996 by Congress, on the power of state prisoners to get habeas corpus relief, that there is no possible way that Mr. Skinner can bring this DNA claim in federal court, both because he's already had one habeas corpus petition and you generally don't get 2, because he's too late, because of the fact that his lawyer didn't ask for the DNA to be tested at the time of the trial, and that's held to be a waiver of the right to have it tested thereafter. There's probably 6 or 8 different reasons why, if he brought a habeas corpus petition now with this claim, he'd be thrown out of federal court without a hearing. So he didn't seek review in habeas corpus. He went a different route, which is to invoke the same statute, the civil rights statute that John Thompson has been trying to use, 28 U.S. Code 1983, alleging that his constitutional rights were violated by the state of Texas when they refused to let him have the evidence to test. And by the way, he's not asking for the money to do it. They've raised that themselves. They just want access to the DNA so that they'll be able to do this testing. The problem with bringing a civil rights action is that you're not allowed to challenge a conviction by bringing a civil rights action under this civil statute. If you're challenging your conviction or your sentence, you have to do it in habeas corpus. If he has to do it in habeas corpus, he's out of court. He can't do it in habeas corpus. So he has to find a way of bringing this as a civil action under 1983. He is arguing that he's not actually challenging his conviction. He's simply trying to get the evidence. The state says, yeah, well, why do you want the evidence? Because you want to challenge your conviction. He says, well, that may be true, but the case law says that so long as the direct result of the lawsuit isn't the invalidation of the conviction, you can bring it, and indeed have to bring it as a civil action and not in habeas corpus. On the other hand, once you succeed in the idea that he's properly in civil court rather than bringing a habeas action, then there's a whole other doctrine, the Rooker-Feldman doctrine, which says that federal district courts can't review the outcome of civil litigation in the application of a lot of the facts in a civil case in a state court. The federal courts don't have jurisdiction. Only the Supreme Court has jurisdiction to do that. So he has to argue that he's not actually challenging the outcome of the litigation in the Texas courts. Rather, he's challenging the Texas statute, which governs the analysis of DNA on its face as construed. And the particular problem that he's attacking is that Texas has a hard and fast rule that if you could have asked for the evidence at the time of trial and didn't, or rather if your lawyer didn't ask for it to be analyzed, you're out of court forever. You can't ever analyze it later. Skinner says he wanted it analyzed. His lawyer said no, and his lawyer turned out to, this is, someone in West Texas, and everybody seems to be on their way to jail, from jail. The DA went to jail. His lawyer was disbarred and stealing money. Well, he was the DA just before he was Skinner's lawyer. There's all this extraordinary interconnection between the lawyer who was disbarred and the DA who wouldn't turn over the DNA, and on and on and on. And Skinner's sort of a bystander to all this, saying, what on earth is going on here? But that is the saga. What the Supreme Court will do with this, frankly, I don't know. I'm inclined to think that the other wrinkle of all this is that just a year ago, the court said that there is no basic, no freestanding constitutional right of a prisoner to have DNA tested. The Constitution doesn't provide it. The only thing the Constitution provides is some avenue that the state courts are in charge of to decide when you do and don't get to test DNA. And so Skinner is, again, trying to thread that needle by saying that the Texas procedure is unconstitutional because of this hard and fast rule that you can't test it later if you didn't ask for it earlier, that admits of no exceptions, that doesn't allow a hearing, that doesn't allow you to explain why you didn't ask for it, why your lawyer didn't ask for it, why you should have asked for it, why it isn't fair to execute you because of your lawyer's failure. None of that counts in Texas. You either asked for it or you didn't. If you didn't, go away and don't come back. It's been the response of the Texas courts, and that's what he is attacking. And that is the only sliver of daylight that might give him access to the DNA. You might say, well, it's a good sign that the court granted the stay. Maybe there were 5 votes to give him some relief, but it only takes 4 votes, not a majority, to grant cert. And there is a tradition, not always followed, but usually, that once cert is granted, someone will provide the 5th vote to stay in execution so that the matter doesn't become moot by the inmate's execution before the case can be heard. So we don't know that there are 5 votes, and it actually might be rather surprising if there are. You do have to ask, however this case comes out, if the DNA isn't tested and Mr. Skinner's execution is rescheduled and he is executed, what will Texas do with the evidence then? It'll still be sitting there. They're going to test it after the execution? They're going to give it to someone else? Or more likely, as Virginia did a few years ago in a similar situation, will they destroy it? Say, well, there's nobody left who needs this, so I guess we'll free up some room in the cabinet. This is, the quality of the sort of capital case that the Supreme Court is hearing nowadays, and we'll see as with all of these cases.